everyone. The PWFA regulations are here, and I am here to tell you everything you need to know. Hi, everyone. My name is Ari Kwiatkowski, host of the Labor and Employment Podcast. If you're a listener of the podcast, you've probably noticed that I've been absent for a few months. So this will tie into my fun fact that I normally make all of our guests share. But I actually was on maternity leave for about 6 months, and I've been back for a few weeks. So I am back in action hosting the podcast. And given that my daughter is now 8 months old, obviously, as I mentioned, I was on leave. I think this is a very timely topic for us, the podcast, and me to talk about. So if you are a long listener of the podcast, you know that last year, the Pregnant Workers Fairness Act went into effect. That's a federal anti-discrimination statute, a new federal anti-discrimination statute that was effective as of last June. So just a refresher, or you're probably wondering, Ari, what's the Pregnant Workers Fairness Act, or the PWFA as I'll call it? Just as a refresher, the PWFA is kind of like the ADA, but it is limited to conditions related to pregnancy or childbirth and accommodations needed for those conditions and accommodations that are reasonable, that are needed as it relates to childbirth and labor. So if you think PWFA, you should think ADA. Basically, it is a similar statute. It requires that employers provide reasonable accommodations to qualified employees for as a result of pregnancy or childbirth, including labor, and related conditions or conditions related to childbirth and labor. So the PWFA has been in effect for about a year, and we've been waiting for the EEOC to issue its regulations. As I mentioned, the law is a federal law, and it is enforced by the United States Equal Employment Opportunity Commission, or EEOC. And if an employee believes that they have been discriminated against under the PWFA, they are entitled or can file a charge with the EEOC, and the EEOC will investigate the allegations. So, that's kind of just a refresher on what the PWFA is. I will note that the PWFA is limited to requiring employers to provide accommodations. So that's really the purpose of the statute. So the EEOC did finally issue its regulations or proposed rule, the final version of them back in April, and they are set to go into effect in June. So very soon this month, I believe June 18th. So I'm breaking it down and I tell you what you need to know and what's new as it relates to the regulations. So as I noted, the PWFA requires that an employer provide reasonable accommodations for a known limitation as a result of affected by or arising out of pregnancy, childbirth, or related medical conditions. And the regulations explain a little bit better, what that means. So you might be wondering, what is a known limitation? And the regulations do tell us a little bit more or give us some more information about what the law means. Known in the context of the law means that the employee or employee's representative communicated the limitation to the employer. So that gives us a little bit more information, because what is known to the employer was a bit amorphous or unclear before the regulations were issued. The regulations also define limitation. Limitation means a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. So I think that gives us a little bit more information. And in a lot of ways, the PWFA does follow the ADA, or the Americans with Disabilities Act. But, there is some additional information and some differences between the two, which we'll go over. So the physical or mental condition that is a limitation under the regulations is, one, an impediment or problem that may be modest, minor, and or episodic, a need or problem relating to the employee's health or the health of the pregnancy, or seeking health care related to pregnancy, childbirth, or related medical condition itself. So if your employee needs a reasonable accommodation and the request is to have some time off or to have a schedule modification to go to a medical appointment related to the pregnancy or childbirth, if they're still working or prior to the time they go on leave, that's something that you definitely will need to consider as an employer and grant that accommodation. I did want to note that under the PWFA, the condition can be a limitation under that statute, whether or not it meets the definition of disability under the ADA. Moving on to qualified employee, the regulations do provide us some guidance on who a qualified employee is under the PWFA. This is a little bit different than under the ADA. So the reason it's different is because the PWFA does include a temporary time frame that is not specifically explained or included in the ADA. So under the PWFA regulations, if an employee cannot perform all essential job functions, even with a reasonable accommodation, the employee can be qualified under the PWFA if the inability to perform an essential job function is for a temporary period. So, and we talked about this a little bit last year because this provision is in the original statute, but luckily for us, the EEOC has given us a little bit more information on what this temporary period means. So under the regulations, temporary is defined as lasting for a limited time, not permanent, and may extend beyond in the near future. So for a current pregnancy in the near future is generally defined as 40 weeks from the start of the temporary suspension of an essential function. So what that means, what the regulations are really getting at is to say that if you have an employee or you are an employee and you request a reasonable accommodation, the length of that accommodation or the need for the accommodation could be temporary, and that could be the length of the pregnancy if we're talking about a current pregnancy. So that does give us a little bit more information, but depending on the nature of the accommodation, obviously the length of the pregnancy or 40 weeks is a potentially very long period of time. I will say this, the PWFA regulations include a provision for conditions other than a current pregnancy, or providing temporary accommodations for a temporary period for conditions other than a current pregnancy. But in that situation, the regulations do not define in the near future as any particular length. So we'll have to wait and see on that and how that actually plays out. So let's talk reasonable accommodations, and let's talk about what the EEOC regulations say about what could be a reasonable accommodation under the PWFA. So the regulations do give examples of reasonable accommodations. The examples are not exhaustive. So that means, we shouldn't be limiting, or the accommodations that could be considered reasonable are not limited to this list. But for example, and I'm going to read off a list, the regulations say that frequent breaks, sitting or standing, schedule changes, part-time work, paid and unpaid leave, telework or working remotely, providing the employee with parking, providing the employee with light duty, temporarily suspending one or more essential functions, which we just talked about, of the position, acquiring or modifying equipment, uniforms, or devices, and adjusting or modifying current examinations or policies could all qualify as reasonable accommodations under the PWFA. Now, if you're familiar with the ADA, the PWFA is similar in that whether or not an accommodation is reasonable under the circumstances is really a fact-specific, case-by-case inquiry. And of course, the PWFA does require that an employer engage in an interactive process and a dialogue with the employee when a request for an accommodation is made. So the regulations also give us a little bit more information or expand on the definition of pregnancy and childbirth. According to the regulations, pregnancy and childbirth include a current pregnancy, past pregnancy, potential or intended pregnancy, and that also can include fertility treatments. Labor and childbirth, and included in childbirth is a vaginal childbirth or a childbirth via cesarean delivery. The regulations also give us a little bit more information on what conditions could qualify as related medical conditions under the statute and the regulations. So there is a non-exhaustive list in the regulations as well for what is a condition that is related to a related medical condition related to pregnancy or childbirth. That includes miscarriage, termination of pregnancy, postpartum depression, anxiety or psychosis, migraines, hormonal fluctuations, and there's several conditions that are listed in the regulations. And again, that list is not meant to be exhaustive. So there are other possible conditions that could qualify. I also wanted to note that one of the related medical conditions included in the regulations is abortion. Shortly after the proposed rule was issued back in April, I think 17 states joined in a lawsuit against the EEOC to enjoin the final implementation of the rule on the basis that abortion was included. So we'll have to, keep an eye on it and see how things progress as that case moves through the courts. And the last and final thing I wanted to mention is lactation accommodation. And again, this is just meant to be a general overview to give you some highlights of what you need to know from the regulations. But if you have any follow-up questions, please feel free to reach out on LinkedIn, shoot me an email, give me a call. Would love to chat about it. So the last thing I wanted to mention is lactation accommodation. If you're an employer in New York, and we did some episodes on this last year, you already know that in late 2022, the New York State legislature made some updates to the labor law, which required some enhanced accommodations or protections for employees who were expressing breast milk in the workplace. There's an accompanying federal law, which is called the Pump Act, but the Pump Act did not have quite as many requirements as New York law. But in the interest of providing additional protections for employees expressing breast milk in the workplace, the PWFA regulations actually include some additional requirements as it relates to lactation accommodation. But the bottom line is that if you're an employer in New York State, chances are, and we hope, you are already complying with those new rules. Thanks everyone for listening today. I hope this was helpful. I wanted to give you the highlights, the high points of what the new PWFA regulations say. And I will be back in the studio in a couple weeks. I think our next episode, Lee Jacobs will be back, and I think Rosemary may join him to talk about a few other issues. But I'll definitely be back on the podcast. I'm glad to be back. It's good to see everyone, and talk soon. The Labor and Employment Podcast is available on barclaydamon.com, YouTube, and all your favorite podcast streaming platforms. Like, follow, share, and continue to listen. Thanks.